So today I want to talk about confidentiality agreements. But firstly, what does confidential mean? Well, it's when information is disclosed under an obligation not to share it with anyone else. In a commercial context, obligations of confidentiality usually come up contractually, where the parties make promises to each other not to disclose the information. They also come up in a funny branch of law called equity, but that's a whole nother video for another time. In practical terms, it's actually pretty rare to need a confidentiality agreement because usually there's already some kind of contract that incorporates confidentiality obligations, like a construction contract. You might want one though if you're going to disclose commercially sensitive information like pricing, IP or innovation, and you don't yet have a contract that creates that duty of confidence. For my clients, that would often be where they are getting into discussions about an upcoming project opportunity. The other party might be a client or they might be a collaborator, but either way, the guts of the confidentiality agreement are going to be the same, and you want it to include 4 important parts. Firstly, identify the parties. Is it a corporate recipient or will it be individual people? You want to make sure that the specific recipients understand and agree to keep the information to themselves. Secondly, include a wide definition of confidential information so that the agreement captures the information no matter how it's shared, whether that's orally, in writing or electronically. Thirdly, you want it to have a narrow purpose for which the recipient's allowed to use the information. In a teaming agreement, that might be to pursue a named opportunity with a named project sponsor. Collaborators are often competitors in other contexts, and you don't want them blabbing your pricing info around town. And if the other person's a client, well, you don't want them to beat you up with your pricing breakdown on a future project either. And finally, include a time frame. Make it realistic so that you don't end up quibbling over it. If it's your pricing info, it's going to be out of date in a year or two, so there's no need for a 10-year term. So that's 4 important terms, but I want to mention something else you should think about for strategic pursuits, and that's exclusivity. If you're sharing commercially sensitive information with a future client or a partner to help them win a project, you want to try to make sure that you're on the same team and that they won't just use your info as a price check and then hang you out to dry. And you also want to confirm your ownership of any valuable IP that you might be sharing during the process. So, for all of you that are talking to clients and partners about exciting opportunities in 2021, you might want to think about whether you need a professional confidentiality agreement drafted. Thanks for watching. Bye till next time when I'm going to talk about the critical path. See you then.